and her BA degrees from the University of Virginia, where she served on the editorial board of the Virginia Law Review. And before entering practice, she clerked with the Fifth Circuit Court of Appeals, U.S. Court of Appeals. She's a member of the American Law Institute. We are so fortunate to have her today. She speaks around the globe on family and health law issues. In 2010, she delivered the Sidney and Walter Seiben Distinguished Professorship Lecture at Hofstra. She presented the Distinguished Speaker Series at St. Louis University Center for Health. Her work has been featured in many major papers, and including the New York Times, Morning America, this weekend in the Tulsa World. So we are thrilled to have her here. Our other distinguished speaker today is probably more familiar to you, Dean Tamra Piety. She's a nationally recognized legal scholar in the field of commercial and corporate speech, and her most recent book, Brandishing the First Amendment, was just published by the University of Michigan this past fall. She's been researching in this field for over a decade. In 2003, Dean Piety contributed an amicus brief for the Sierra Club in the Nike versus Caskey case. In 2009, she was invited to be a panelist before the Federal Trade Commission on the question of regulation of marketing junk food to children. In 2011, she debated James Bopp, Jr. about the consequences of the Supreme Court's decision in Citizen United in 2010 that significantly expanded the scope of corporate participation in the political process. She's also widely published in journals such as the Michigan Law Review First Impression, Case Western Reserve Law Review, Cardozo Law Review, Temple Law Review, Seattle Law Review, and many others. Many of you know that Dean Piety is an experienced litigator whose teaching subjects include evidence, scientific evidence, and law and the mind sciences. And she earned her JD from Miami School of Law, where she was articles and comments editor for the University of Miami Law Review and Order of the Coif. And she earned an LLM from Harvard Law School, where she was executive editor of the Harvard's Women Law Journal. And then she went on to serve as judicial law clerk for the Honorable Peter Fay on the Court of Appeals for the 11th Circuit, and as interim clerk for the Honorable Irving Goldberg on the U.S. Court of Appeals for the 5th Circuit. She was, before coming to University of Tulsa, a teaching fellow at Stanford, and she's also been a visiting professor at University of Missouri and at Florida State University. So we welcome both of these incredibly distinguished speakers. Professor Wilson will be our first speaker, so let's please welcome Professor Wilson.
Well, thank you. I want to thank Amanda and Jackie, the Federalist Society, TU, obviously my longtime friend Marianne, who you can see is not objective, and hopefully my new friend, Dean Piety, for having this conversation. So what I want to do in about 20 minutes is really go back to the full-scale clash that has erupted between the Obama administration and religious groups over the sterilization and contraceptive coverage mandate. Basically, what I want to do is recap and perhaps briefly reframe that clash as part of a broader struggle over abortion. Now, it is often overlooked, I'm hoping this works, by the way, this is Prezi, very new for me, but it's often overlooked that there, in fact, have been two different religious objections raised in opposition to the mandate. One is to contraception itself. The other are to emergency contraceptives, or ECs specifically, which for most of us, I believe, has far more force. Here, the moral valence of the religious objection changes suddenly from, I don't want you to have sex that doesn't result in a person, an idea that many people can't really get their minds around, to a different objection, which is, I don't want to pay for you to destroy a life and being. That one, I believe, has far wider resonance. Now, the Obama administration, to its credit, has attempted to engage both objections with its famous, or some would say now infamous, accommodation. I'll describe that to you in a few minutes. And has now said that it will do no more. Now, that's not really surprising, because the administration has basically become trapped between religious objectors on the one side and women's rights groups on the other. And those groups have pushed back against greater leeway for religious objectors on a number of grounds. I'm going to actually talk about two of those grounds today for why they believe that we should not give any more quarter to religious objectors. One is factual, namely that ECs, or emergency contraceptives, act as contraceptives and only as contraceptives, they say, so that giving more accommodations simply endorses what they believe to be a silly idea, that ECs act as abortifacients. And if they're right that these things don't act as abortifacients, then they say your religious objection, if you share that objection, has no scientific support. So I'll come back to that factual claim. Now, the second claim for not wanting to give any more room for religious objectors is one that the ACLU and others have made, but here I'm reading from the ACLU. They have said that religious objectors or religious liberty does not, quote, come with the right to impose one faith on others. Now, both of these grounds, I will argue, have some support and, in fact, have intuitive appeal, at least until they're unpacked further. I'll come back to that. So let me start with the very beginning, which is the Federal Healthcare Reform Law itself, the ACA. Now, if there's one lesson from the past year, I believe it's this. Unlike other culture wars, culture wars are never won. Now, few would describe abortion itself as a settled issue that either side had won, especially with 1.2 million abortions annually, and with a steady stream of state legislation to, quote, evince respect for fetal life, or as family planning advocates would say, to erect more and higher hurdles to a woman's right to abortion. But in one crucial respect, the clash over abortion had in fact settled out and reached a stasis. For nearly 40 years, abortion objectors could count on two ironclad guarantees. First, that no one would ever have to assist with an abortion if doing so was contrary to his or her religious beliefs or moral convictions. And second, that no federal tax dollars would, quote, be expended for abortion. Now, those guarantees, which were made in the Church Amendment months after Roe v. Wade in 1973, and again in the Hyde Amendment 3 years later in 1976, I see you shaking your head, appeared unassailable. Indeed, far from being under constant retreat, Congress expanded conscience guarantees in successive pieces of legislation since 1973 in Congresses under both Democratic and Republican leadership, and these acts were signed into law by presidents from both parties. 47 states, in fact, sorry, let me come back to that. Excuse me, I'll come back. But 47 states basically paralleled these conscience guarantees in federal law in their own laws, their own state laws. And like those conscience protections, Congress has renewed the Hyde Amendment every year since 1976 with strong bipartisan support. So at a time when abortion in the United States remained a deeply partisan, contested issue, conscience protections were not. Now, great social changes often prompt a reassessment of the social contract between the state and its citizens in ways that no one could predict at the beginning of a social movement. But certainly with the mandate, many feared a rollback even before the ACA became law. So recall Representative Stupak, who asked President Obama for and received a promise that public funding would not be used to pay for abortions. Indeed, Congress included its own promises in the ACA that existing conscience guarantees would not be rolled back. Now, fast forward to the last year. We have witnessed, in the words of one of my colleagues, Tim Jost, probably the foremost commentator on the ACA, I see you shaking your head, a political maelstrom over the administration's regulations to implement the ACA. These regulations require nearly all employers and health insurers to cover sterilization procedures and contraceptives, like emergency contraceptives, specifically Plan B and Ella. Now, a hue and cry arose, as you know, from the faith community, which said that mandated coverage places the bulk of religious employers in the, quote, untenable position of having to choose between violating the law and violating their consciences, specifically their religious belief that life begins at conception and should not be destroyed. Now, while the regulation exempts churches qua churches, its cramped definition of religious organization provides no refuge for religiously affiliated universities, hospitals, and social services agencies like the Salvation Army or Catholic Charities. Even supporters of the ACA found this to be too much. The Catholic Health Association, which had supported the ACA from the beginning, said, quote, from President Thomas Jefferson to President Barack Obama, we have been promised a respect for appropriate religious freedom. Now, after saying that faith organizations had to provide contraceptive and sterilization coverage, the Obama administration then took a series of steps to quell the growing rancor over the mandate. First, it extended the deadline for compliance by religious objectors for 1 year, a concession that was dismissed by critics as, quote, kicking the can down the road. And then the president, as you just saw a second ago, but we'll listen to him, I'll pause him there. And you know that that itself was met with derision. So 500 university presidents, scholars, religious leaders, and others, led by Archbishop Dolan, labeled that accommodation unacceptable and accused the White House of hiding a grave violation, these are their words, of religious liberty behind a, quote, cheap accounting trick. Now, the claim of religious objectors to be exempted was met by equally vigorous claims on the other side by women's groups that all women, quote, regardless of their employer, should be able to access the birth control coverage benefit. Women's rights groups praised the Obama administration for establishing a, quote, major milestone in protecting women's health. Now, religious objectors have had to fend for themselves in the political process because they're not shielded against the burdens of generally applicable laws as a matter of federal constitutional right. How many people have had con law, right? This is Employment Division versus Smith that I'm reading you. Okay, now, those same objectors, though, may receive more robust protections under the Federal Religious Freedom Restoration Act, which, as you see here from the Beckett Fund website, has become the backbone for the metastasizing number of suits challenging the mandate, including the one from Hobby Lobby that I mentioned in the Readers Forum this weekend. Now, I'll leave it to others to make predictions about whether those constitutional or RFRA-like claims are likely to succeed. Let me say this instead. It is clearly better to secure through the political process an accommodation that both sides can live with. And that's where the pushback and the need to engage it squarely comes in. Now, as I said before, there are two grounds that family planning advocates and women's rights groups have asserted for why religious objectors should get no more help from the administration. Some say, for example, as the New York Times did this summer, that ECs like Plan B and Ella do not act after fertilization, period, full stop. Now, notice that this article describes two different drugs, Plan B, which is effective up to 72 hours after unprotected sex, and Ella, which works up to 120 hours after unprotected sex and is much more effective in preventing pregnancy than Plan B. For instance, Ella prevented 85% of expected pregnancies to Plan B's 69% in one study alone. Now, it's important to remember that religious objectors did not make up this concern that things like Plan B and Ella work after fertilization. They read it right off the FDA labels, which I include for you here. And the labels for both of these drugs say that sometimes the drug acts to prevent the attachment of a fertilized egg to the uterus. Now, as a matter of basic biology, the early embryo has a narrow window for successful implantation. Basically, I show you the progress here. Now, factually, from my review of the literature, it appears that the New York Times is exactly right as to Plan B and its mechanism of action. Since Plan B's initial FDA approval in 1999, the only way that Plan B has been ever demonstrated to operate is as a contraceptive, meaning that it works to prevent fertilization entirely. It impedes the sperm, and it prevents the egg from being released. So in effect, nothing meets nothing, okay? There's no life that begins under any definition of that term. So in other words, Plan B is operating there at that arrow to stop anything from meeting anything. Now, we can agree that if a drug acts at that point, it's just an ordinary contraceptive. I think we can also agree that if a drug sloughs off a fertilized egg at the second arrow, fertilized implanted egg, that would be an abortifacient, even under the government's most restrictive definition over decades. But the big question that everybody misses is what does it mean if it works in the middle? And here, the evidence about Ella, approved in 2010, is shaping up very differently than the evidence about Plan B. A number of authorities believe that Ella's enhanced effectiveness stems in part from post-fertilization mechanisms of action. Ella operates to prevent the release, it's true, of the egg from the ovary and therefore fertilization, i.e. at the first arrow. And in fact, it works that way most of the time. But here's the difference. It doesn't work that way all of the time, it appears. So this 2011 article, sorry about that. This 2011 article concluded that if a woman happens to take Ella in the 5 days after unprotected sex and after the egg has already been fertilized, then Ella's, quote, mechanism of action is much more accurately described as contragestive, since only gestation, implantation, and growth of the embryo or fertilized egg is prevented during that time. Indeed, this author says that this contragestive effect likely accounts for Ella's enhanced effectiveness compared with Plan B. Another way of saying this is the woman, in effect, took the drug too late in that progression, and now it's acting by a different mechanism to prevent pregnancy. Now, other studies also point to a unique time frame and or speculate that there's a unique circumstance and time period in which Ella would have, in the words of this study, a, quote, direct abortifacient effect. Now, we have to be careful here because that term is defined in that article to mean, quote, the loss of the embryo before or after implantation, but either way, a post-fertilization effect, rather than, in the author's word, a contraceptive effect. Now, this would occur when unprotected intercourse occurs within basically a fertility window, which I show you here. See the spikes? If you take this drug within 120 hours or 5 days before ovulation, look at the spike, and not more than 24 hours after that spike or ovulation, and when Ella is taken after fertilization, then it is not acting as a contraceptive. So says Professor Mayak, who is an emeritus professor at Brown University of Molecular Pharmacology, Physiology, and Biotechnology. He believes that Ella instead blocks the immunotolerance effects of progesterone on the maternal and innate immune system, meaning that Ella causes the immunorejection of the embryo at the moment that it tries to implant. Now, as with Plan B, it may be that as we get more and more evidence of Ella's precise mechanism of action, that our understanding of that will evolve as new studies accumulate. I don't know. But for now, it appears that Ella does indeed sometimes act after fertilization, i.e. not as a contraceptive. Now, this unknowable quality, which way is it working for this particular person, actually provides ammunition to both sides. In essence, family planning and women rights groups are saying that you, the objector, cannot know which way this drug acts, so you can't legitimately object because it won't always act in this way. And of course, religious objectors counter that an exemption is warranted, not because they can positively know that by providing EC coverage they're facilitating an abortion sometimes, but because they could not positively know that they are not. So ultimately, this becomes a question of who gets to decide in instances of uncertainty. Now, many supporters of women's access to EC will discount the concerns of religious objectors nonetheless, saying that they are far outside the mainstream. In other words, these are people who are wingnuts, who believe that the destruction of 12 or 14 cells is tantamount to the sort of thing that happens at Planned Parenthood. Now here, significant numbers of women who use contraceptives see the issue just as religious objectors do. We know that empirically. So, for example, they believe that using birth control that acts after fertilization is wrong. I'll give you a study very close to home, a 2005 study of women who were seen in Utah and Oklahoma OBGYN clinics. In that study, researchers found that 53% of women would not use a birth control method that acts after fertilization. 74% said they would not use a method that acted after implantation. And when they were specifically asked, if there was a remote possibility that this drug acted that way for you, would you stop using it? In the case of people who were told that it would act after fertilization, 44% of them said they would stop. Told that it would work after implantation, 69% said I would stop using the precise method that I'm using now. Now, for many of these people in the study, their qualms directly reflected their belief when life begins. 48% of the women reported the personal belief that human life begins at fertilization, and for them, that means these methods are ending a life in being. Now, some people have said to me elsewhere, not here, how representative is Oklahoma or Utah? Okay, but let me give you a few more data points. A 2008 questionnaire at 2 family academic medical centers in the Southeast and a 2001 study of California healthcare providers that included gynecologists found similar results. And studies of women's attitudes across the globe in Europe, Mexico, and Spain document similar concerns about using drugs that act after fertilization by the very same women who were asked to use them or asking to use them. Now, I want to shift to that second ground for pushback, which is basically the claim that no one should have to bear the cost of another's religious objection. Now, the argument for a benefits exemption, i.e. that Hobby Lobby doesn't have to pay for this benefit for its employees or any other objector, is not that the exemption will pose no hardship. Instead, it is that failing to give an exemption is likely to lead to even greater hardships, as I tried to document in the op-ed this weekend. Now, we've heard a lot as a community and as a public about the penalties under the ACA for dropping coverage. What gets missed is that religious objectors, when they have had no other way out, often resort to extreme fixes or what I call the nuclear option. And here, the nuclear option would be to shed coverage entirely. Under the ACA, I'll show you in specific ways that the nuclear option remains available to some religious objectors at no cost and to others at a price, although the penalties will almost certainly be much less than the cost of providing subsidized health care to those employees. So here's a concrete example. Zaytuna College, which sued the Obama administration. It reported on its 2009 Federal 990, the last one that I can find on the web publicly available, that it had 25 employees. Those 25 employees fall outside the penalty threshold of 50 employees. And because Zaytuna objects to the coverage mandates for religious reasons, it can simply drop all of those employees, triggering the nuclear option. And guess what? They pay no penalty at all. Now, for employers that do meet the penalty threshold, which is employers with 50 or more employees, at least one of whom receives a premium credit from the federal government, there would be substantial penalties for failing to provide coverage. But any penalty, although it is, and I will show you, likely to be enormous in some cases, will still be offset by the savings that the objecting institution realizes by dumping their employees on the public exchanges. So think about Notre Dame. With its 16,445 employees reported on its federal 2009 990. It faces a calculated annual penalty of $32,830,000 annually for not providing this coverage. Now, the annual costs of that nuclear option seem at first blush to be almost unsustainable. But a substantial literature has developed showing that private employers will frequently come out ahead financially by eliminating subsidized health care coverage. Why? Because health care costs for the American family last year exceeded for the first time annually $20,000. And employers pick up 82% of those costs for individuals, 72% for families. Now, not all employees will be disadvantaged, it's important to note, by this move. Lower income and middle income employees actually come out ahead by being dropped onto the federal exchanges because the copay that they were asked to pay by their employer is greater than the premium subsidy that they're going to get from the federal government. So they come out ahead. Now, it's also true that employers that provide fewer benefits generally have to gross up pay to compete for employees, although ask yourself whether that's still true in this economy. But all other things being equal, you don't pay benefits, you gross up salary. But an objecting institution that drops coverage isn't going to gross up salary for the missing benefit for lower and middle income employees if those employees, in fact, are going to be made better off by receiving premium credits. Now, all of that is a long way of saying that the nuclear option may not nearly be so great as the calculated penalties that we've heard so much about would lead one to believe. Now, I want to shift and talk for one more minute about something that gets missed entirely, and that is what happens to ordinary individuals who share the same kinds of religious objections that people or entities like Hobby Lobby themselves have expressed in litigation. You never hear about these ordinary individuals. Yet the impact on them is likely to be as great or greater than the impact even on these very, huge corporations. So I'm just guessing here, but the man that's shown on the left is John Garvey. He is the president of Catholic University. And I'm betting that John Garvey shares the religious objections that Catholic University, which has sued the Obama administration, has. So what happens to the John Garveys of the world, or people who have a lot less wealth? What happens to them if they object to abortifacients or abortion, quote, abortion causing drugs, to use the Hobby Lobby words, or contraceptives themselves? Now, the impact has been almost entirely neglected, but under the ACA's individual mandate, failing to obtain coverage prompts a monetary penalty. I've shown you some of them down here, but for the family with a median family income of $49,400 and some dollars a year, they face a penalty of $2,025 for not not complying with the individual mandate. But the real penalty for them is not the $2,000 they've got to pay the government now. It's actually not having any health care at all, because they cannot go out in the marketplace and purchase an unobjectionable plan. Now, it is true that the ACA does provide some ways out. I'll tell you about them. One, you can be Amish. There's a religious exemption for the Amish. I don't think that gets, President Garvey very far, because he's a committed Catholic. Two, you can be a member of a healthcare sharing ministry. A healthcare sharing ministry is not the same thing as an insurance company. You can think of it as like an investment pool. They don't have financial reserves. They do not guarantee payment. So, and by the way, they're grandfathered in, so there's a very limited number of them. You're not going to see a market evolve to take care of all the religious objectors, I believe. And it's not a healthcare product, an insurance product. And then third, you can do what I just described to you, which is to go naked and have no healthcare coverage at all. Now, it strikes me as deeply ironic for a law that was supposed to provide health care coverage to everybody to force these religious objectors to take no coverage at all in order to solve the collision between their consciences and the mandates of the law. So I'll end on this point. I think it's a sad thing that we force these individuals or groups to basically make a choice between their religious convictions and the demands of the law. By taking extreme measures, that's basically their only way out of that, sometimes at great personal cost to them. I personally believe that a benefits exemption would give religious objectors a less extreme way out. The Obama administration has a ready vehicle for providing that way out, at least for the individuals. It's called the hardship waiver, which they haven't promulgated regulations on, and I believe the Obama administration should take it. Thank you.
Wow, 10 minutes, big law. This law or this question raises, questions. I brought this up in my expert evidence class today because it raises questions of expertise, not only of biology and medicine, but also of theology. The Hobby Lobby lawsuit brought the lawsuit and pleaded in their complaint, that they were attempting to conduct their business in accordance with God's law. Not, that as they understood it or as he understood it, but rather, more affirmatively in accordance with God's law, which might require a theologian to parse. So I'm really going to try to talk really briefly about some things which I think this is not and what it is, and particularly the part of it that is related to my area of expertise in terms of corporate and commercial speech. What this is not, at least as to Hobby Lobby, is a case about contraception. I mean, Hobby Lobby, and this is in sort of preparing for this is a sort of a moving target because we're shifting back and forth between the Hobby Lobby lawsuit and sort of the more general objections to the ACA, and some of those have been about contraception, but Hobby Lobby's is not. So Hobby Lobby's lawsuit actually says in the complaint that they have no objection to contraception that doesn't act as an abortifacient, which I think the IUD would be a common example of that. So they really are focusing their objections to Plan B and Ella, and if we go to Professor Wilson's observations, that really boils down to Ella. So this seems to be largely about Ella. This is as with respect to Hobby Lobby. With respect to the free exercise, I mean, and we have in the First Amendment both the free exercise and the Establishment Clause, right? So this is meant to protect us both with the freedom to exercise our religious freedoms, but also freedom from religion. And the question, the sort of democracy question that gets raised here is, who gets to decide? Who gets to say for you what some decision like this is going to be, and whether or not this is going to intrude on your freedom of exercising your religion or freedom from religion. And what the Hobby Lobby case does that's sort of new or different or unusual is that it brings this case on behalf of not an individual, but on behalf of a corporation. Now, we've also heard from Professor Wilson that this is not really an issue with respect to the businesses because the penalties to some extent can be maybe not a desirable option, but they do have a way out, and that's this nuclear option. I defer to her greater expertise on this and say, let's take that as a given. If we take that as a given, then it seems that the argument that is being proposed really comes down to the individual objection. And I would just submit to you that there are people who are also pacifists, Quakers, Buddhists, who are pacifists, who object deeply to having to war and their tax dollars more, and these kinds of objections to paying taxes, which have been raised from time immemorial to federal taxes, have been pretty uniformly rejected, that you don't get to reject certain parts of the sort of federal compact or generally available rights by saying, you have a religious objection to them. Christian Scientists, if this organization was run by Christian Scientists, might object that they are objecting to medical treatment altogether, and so it somehow is objectionable to them. And so I want to ask, what is the objection to the individual that an insurance plan that they purchase offers an option that they are not required to take? How does that interfere with their free exercise of their religion, that somebody else might make a choice with that product that they are not required to take? I mean, this is not a case where the government is requiring anyone to take contraception or to get an abortion or anything like that. So, the issue is, does it infringe on your liberty that the insurance product that you buy is one that provides coverage for a product that you may not want or that you may not need? And I would submit that, I don't think so. With respect to the individual company, the sort of corporate rights, there's this fine quote that is often used in this context about how a corporation has no body to kick, no body to kick, no soul to damn. And that last part, the soul to damn, is a very, it's kind of a throwaway phrase, but it ends up being really critical to this idea about whether or not a corporation can exercise religious rights. We could also put sort of parenthetically to one side, I mean, there's this issue, and I'm not a doctor of theology, but there's this question about whether or not something that you have no choice about, that morality is taken in the context of choice, and it is only through choice that we have moral valence as individuals, as human individuals, and that freedom of choice so that we can make bad choices is part of what makes choices moral, and where you have no choice, then arguably you have no moral. Something's not immoral if it's imposed on you. You could say that about the law, but where the corporation is not a person, but rather a legal person, that is, a person constituted by law to describe to have certain sort of aspects. And, you know, in their lawsuit and in a lot of the coverage about these kinds of things, you'll see, you know, the claim that the company is trying to run itself as a particular kind of company, as a Christian company, or and this is socially conscious is another word that's often used. And we don't have very good accommodations to any of those kinds of attempts in the law. But what we do have is actually pretty well established, and it's largely in the tax code, not surprisingly, definitions of what constitutes a religious organization, of what constitutes a particular type of organization for tax purposes into very fine categories, advocacy groups that are permitted to do one thing but not permitted to do some other things and so forth. And these are categorizations that are defining of the organization. That is, they say what the organization is permitted to do or has the capacity to do. State law defines corporations. State law creates corporations and says, you know, you can create a corporation to do for-profit, not-for-profit, for advocacy. There are municipal corporations. These are the, you know, sort of the ways in which corporate life comes into being. And the question is whether or not that institution, that creature of state law, should have a superior right as to the individual employees to share in some product of a democratically produced, you know, enactment of law. And, you know, this is, I mean, these are like incredibly contentious issues and certainly can't be settled in, you know, an hour or 10 minutes. But I would just say, you know, one of the things that I think sometimes gets lost as we think about this corporate person, or we talk about these very, you know, very compelling for the people who raise them objections to some of these drugs or to abortion as a practice, there are very many people for whom this is a fundamental right. And that the Roe v. Wade decision, as it emerged from a process of rights for women, was viewed as part of a structure that resided the fundamental right to choose how to conduct her life and the contours and what the elements, the constitutive elements, economic, social, and so forth, would be for women resided in the woman, not in whoever, you know, not in the rapist, not in, you know, the church, not in the employer, perhaps, and certainly, and not even in maybe closest family members, parents after a certain age, or a husband. So, you know, that personhood, that sort of dignity that inheres in the person to make choice, you know, is also reflected in that grant in Roe to the women to create their own lives. And this is part of what's being balanced here, is the employer's right to exercise what their objection, and an objection that comes down to, I think, you know, we don't want to offer a product that somebody might use in a bad way. Now, this is, I think some wag had said something like, well, you know, the salary, you pay employees salary. They could use the salary for some way that you don't want them to use it in some more immoral way. And I think Professor Wilson is correct that that's a different kind of quality or category of thing. But, you know, even at its best, this idea that it's, you know, I am providing you a product that you don't necessarily have to use for this purpose that I don't like, as against, I'm going to allow the employer to dictate the opportunities that are provided to you by law on the basis of their religious beliefs, even if you don't share them. And Hobby Lobby has said that they, you know, many of their employees do not share their beliefs. There is some movement in corporate law to try to come up with something called the social benefit corporation, which would sort of try to straddle the ground between a for-profit and not-for-profit organization. We haven't really gotten there in social benefit corporations and how they would act and what kinds of accommodations we could give to to balance the profit-seeking versus some other sort of interest is still a work in progress. But I would say that at least with respect to this particular lawsuit, as it's framed and as the issue is framed here, the interests are just not terribly compelling. But I think we want to leave enough time for questions, and so so I will just leave it at that.
Yep. I know a lot of you have class. If you have class at 1, I encourage you to step out now. It's a good time. If not, I would encourage you all to stay for some questions. We have the room reserved until past 1, so there should be plenty of time, assuming this works with your schedules.
Do we have a microphone for sitting here?
No.
Oh, I'm just going to do a couple quick responses to the dean because she raises some wonderful points that I think are really compelling, and then this should be your time. So, first point about God's law, I think it's really interesting watching how the contraceptive, meaning only contraceptive objection, has torn up the Catholic community. There is a live intramural war within the Catholic Church about whether contraception itself actually is problematic in terms of the coverage. Okay, so I think there is really a question about whose views when we say who speaks for the church or whose views matter. I stripped that down a little bit in some ways in response to another point that the dean made, which was, Hobby Lobby is a person. They don't have a soul to, not a person legally or truthfully, actually, and they don't have a soul to damn. And I think that sort of misses the point because you're right, it's very complicated when you're talking about employers getting exemptions. But there's certainly a soul to damn. It's the people who run Hobby Lobby who have to decide to pay for this or not pay for this, or to comply with the law or not comply with the law, or to eat the penalty or dump their employees on the exchange. Somebody, in fact, is making these decisions, and somebody is led by religious views and objecting. So for me, it really becomes a fight. Is that really to give them the ability to object at sometimes the expense of their employees? Should we be willing to do that? And there I have actually a different sort of set of responses. I haven't suggested that this is a right, so I'm not arguing free exercise. Notice that. I'm not arguing Smith. But in Smith, the court directly invites religious objectors in that particular case to go into the political process to find the protection that they're not getting out of the First Amendment. And that's what I'm saying has to be done here, and that involves directly and squarely meeting those objections. Now, one of the objections that I didn't talk about, but the dean did pick up on, is the idea that we've had a long time pacifists who've been told, you know what, we're going to use your federal tax money to fight a war in Afghanistan. And they have not gotten relief from the courts. But they haven't gotten relief from the courts because, again, Smith says, go back to the political process. And here I'm trying to turn back to the political process. Now, why would we not give those pacifist objectors some room or some quarter? And I'm arguing that we should here. And there's a couple of responses to that. One, I think there is something to the idea that when we pay taxes, we all get generalized benefits. We get roads, we get wars. Yes, it's true. But there is an intervening decision maker in that process between when I write that quite considerably large tax check and when it gets spent in some God knows where, okay? And all kinds of things come in the middle, and it's really hard for me to trace the dollars in the check that I wrote to that result. Pacifists really believe that that's traceable. So I'm not trying to minimize what they believe, but I think there's a difference. Now here, I know where you're going. Here's the woman who has to decide to take the pill pack or the Ella or whatever. And here I just want to drive a wedge right down the middle of the mandate. Peel Ella off. Peel it off. Just say, fine, it is not part of this coverage mandate, and that leaves only the objection to contraception. And I think you would find a lot less division about this. I may be wrong about that. Now your turn.
Well, no, I was just going to say, yeah, I mean, we could probably agree on peeling L off. No, talking about the political process, I mean, one response to this could be, yeah, we had a political process and it resulted in the ACA, and not only the ACA, but indeed the Supreme Court's ratified it, you know, and so the whole purpose of First Amendment objections to some extent is a counter-majoritarian protection, right? It's like not requiring you to go to the political process, because even if you're only one person, you get to reject, you know, you get to exercise your religion, or you get to have your religious objections, notwithstanding the political process.
Well,
So,
I think
you know.
I'm taking a longer view of that political process. First of all, the U.S. Supreme Court's decision in Sebelius was not about this, as you know. These cases are still working their way up. They'll go from the 10th and on up to the Supreme Court eventually. So we will have that longer discussion about what should have been yielded in the political process. And RFRA itself, the Religious Freedom Restoration Act, specifically asked whether the federal government had a less restrictive, you know, less intrusive, less dramatic way of preserving access. And I want to be clear here. I think it's not a satisfactory answer for people who oppose the mandate simply to say $20 for a pill pack, you know, where's the harm, right? If you don't have $20 to pay for a pill pack, you don't have access to contraception. I'm not trying to say that women should not have access to this. I'm not even trying to say that they shouldn't have access to things like Plan B, because it is expensive. What I am saying is that the way the Obama administration tried to both guarantee access and make a nod to religious freedom was not satisfactory and is likely to be counterproductive. And that we need to go back to scratch and find a way both to have access and preserve as much religious freedom in a plural democratic society as we can. And I think the answer to that is massive expansion of Title X. Massive expansion. Federal government, by the way, I did a back of the envelope calculation. We could take and provide pill packs, not cheap condoms, right, but pill packs to every single woman of childbearing age in the United States for less than we spend in 1 month in Afghanistan. Why did we not go this way, right? Title X, 400% of poverty is going to be way less than even that estimate. Why did we not go that way? And I think that's the political question on the table. And as far as I could tell, it's not over. I don't know. Anyway, your questions. Yes, ma'am.
Earlier in the discussion, you mentioned like a hardship waiver.
Yeah.
I'm not familiar with that. Would you mind maybe explaining that?
Yeah, I don't think that actually will get, I kind of elided a little bit. I'm not sure it would get us everywhere I want to be, right? But the hardship waiver, as I understand it, would be a reason why an individual doesn't have to participate in the mandate. Okay, so think about the Amish. This is another political process claim, right? The reason the Amish got an exemption is because they had one in the Social Security Act. And the reason the Amish are exempted from the Social Security Act is they don't believe in sort of collective insurance. They take care of themselves. So they don't pay in because we expect that they won't take anything back out, right? Hardship waiver is sort of a way of saying, okay, fine, you don't have to comply with the individual mandate, but we still need those people to be able to buy health care in the market that's not objectionable to them. So even if you let them a way out, once the government has federalized all of these healthcare markets, you have to have the government itself allow a product to be sold that does not include Ella or does not include contraceptives, right? So the hardship waiver will keep you from paying that massive penalty, the $2,000 for the family that has about $50,000 a year, right? But it won't give you the healthcare product that I think is really the penalty for not complying. So, but it's a possible way out. They would have to do two things.
So as part of your proposal or idea to fix the problem is to allow for insurance companies to be created that don't have contraception?
Yeah.
Would that be okay by the law?
How about a healthcare plan that doesn't include contraception? And the only people who want to participate in are the ones that don't like it. And guess what? They wouldn't even have a cheaper product. So people like Anoop Galani at Chicago have calculated that, you know, people talk about how much contraceptives cost. Well, it turns out the contraceptives prevent pregnancies. And pregnancies are about $15,000 a pop for most insurance companies, and that assumes that there's not anything really deeply wrong going on with the kid or the pregnancy, like a C-section. C-section is totally expensive, okay? So they would participate in their own, I don't know, souped up, a little bit more expensive insurance plan that doesn't include this one kind of coverage. And then it isn't actually shifted to me. I don't want to be in an insurance plan with people who want more expensive pregnancies, personally, because I just don't want to pay for extra stuff. right? And you wouldn't do that if you leave them in their own little insurance plan. But that would require the federal government to say, we're going to allow an exchange to sell this kind of product. Dean, do you have any responses to any of that?
No, it's like that the point that I made before is like it seems to me a sort of attenuated point to say that it offends your principles to buy insurance that includes a benefit that you don't need to accept on. So it's like it's hard to imagine a collective of anything, whether insurance or government or something, where you could meet everybody's objections and still have a collectivity. I mean, that is part of, deciding, like actuarial kind of decisions in terms of offering insurance. You're going to have different coverage, and you certainly wouldn't want people to try to start like making decisions about like I don't want you to hire people who might be high risk of high insurance claims, and so we're going to discriminate against the ill, so that kind of thing. So
yeah, and I just take a different view. I mean, I do think that the religious objector who's worried about facilitation really thinks they're going to hell. I mean, I really believe that, and I think this is different than taxes. It's not so attenuated. They know I'm paying for this coverage that includes this specific thing, and that some of the people in this pool will use this specific thing that they, in fact, are paying for or subsidizing. Now, we didn't take such an impoverished view of facilitation when we were talking about apartheid in South Africa. Remember people who were dumping their stocks and selling companies off because they were like, I don't want that evil on me, so I'm walking away from it. So we take a broader view of facilitation in all kinds of contexts. It's just interesting that we don't take it here. And I think it's because you're trying to preserve access that women actually do need, right, to certain kinds of coverages with that religious objection, right? Or you're actually setting it up as a forced contest between those. It's not a forced contest. You can have both. So.
But I don't understand why it makes a difference with the fact that the government permits that evil to be taking place, period, and it being part of the insurance plan. I mean, I just really don't. I mean, it begins to sound almost like that somebody is doing evil someplace and so somehow contributing to it, because you're not necessarily going to be contributing to every dollar that you get back, right? Like, so you don't, in an insurance plan, you're not going to necessarily get back everything that you've paid in, because your claims may not be, or you may actually make more claims on it. So there's not a dollar for dollar matchup of what you've paid into your insurance plan and what you get back out of it.
Yeah, but I think, just trying to take as seriously as possible the claims of objectors. I think what the employer is saying is these employees would not have this coverage but for my subsidized health care employment plan. So it literally is, but for the choice that I'm making now, they would not receive this thing that includes this objectionable. And I just take it at face value. If they say, I think that's complicity or facilitation, that they really believe it's complicity or facilitation, and that in their minds it's closely enough bound. And there aren't necessarily intervening decision makers like the government somewhere in the middle saying, okay, in this year the plan will cover roads, and it'll cover this thing, and it'll cover that thing, and it'll cover the other thing. At the beginning what those coverage or those essential health benefits are going to be in the plan that you are in fact providing, because there is no discretion.
But what if they were Christian Scientists or Scientologists, and they
Jehovah's Witnesses,
for to antidepressants or to medical coverage, period?
Well, so that's a fair question. So how much should the government go? How far should it go for other religious objectors? And I guess there's a couple of responses. One, I have yet to see a Jehovah's Witness, I don't want to pay for blood products lawsuit, right? This is widely shared ground, especially when you're talking about something that may lead to an abortion. And it does seem, in fact, to break sharply with a social contract that we maintained for 40 years. So I would put Ella to one side. Even as to these other things, contraception, where I don't think there is as strong an objection, I would say give as much religious liberty as you can and freedom while preserving access. And if that means the government takes on the role of providing some smaller subset of plans that are not religiously objectionable, then let's look at how many Scientologists want to come forward and ask for a plan. Or let's look at how many Jehovah's Witnesses want to come forward and ask for a plan, and then we can evaluate whether that's sustainable by the government. But we know there are tons of religious objectors to this. So, yeah, these are their questions.
I read about a study, maybe you were involved in St. Louis, where contraceptives were provided to a number of lower-income women, and it caused a substantial drop in the number of abortions. Is that an expected effect, that
Right.
the number of abortions will substantially drop, and maybe religious objectors will be satisfied by that? 'Cause that's another thing.
No, look, I'm totally with you on that. You cannot divorce the question of contraceptive coverage from the ultimate question of the number of abortions. And again, I'm focused on one of those two objections because I think that's the more compelling and the more widely shared. But I think as a matter of the government looking at, should we provide an exemption only for contraceptives, I think they have to think very hard about what the downstream effects of not providing contraception coverage to these employees. I'm again not saying you drop these employees and don't give them anything. What I'm saying is there's a better way to fix this collision between faith and access than forcing this down on the religious objectors, because they're not going to do what you think they're going to do all the time. They are going to take the nuclear option. We've seen that historically in a number of other contexts. So I think that's a great point.
Take 2 more questions and then let you guys, if you can stay for longer than that and ask questions individually, that's great. But I want to give everybody an opportunity. So
The guy from Vermont?
I guess my question revolves around, there's been a lot of discussion about corporations and can a corporation have a religious identity separate from its profit motive. It's my understanding that Hobby Lobby is a privately held corporation?
Closely held, is it that right? Is that
Yes.
right?
It's a closely held private company.
Would you apply the same religious exemption options to a publicly traded corporation, whereas maybe like a majority shareholder had a strong religious view, or would you just totally like to divorce those two entities?
That's a great question I haven't thought through. I guess my first impulse would be if we can preserve access while having the greatest amount of religious freedom, we should do that. That's a good in a plural democratic society. There, I do think you have a real question that the dean has raised about who speaks for that company, much in the same way that you see this intramural warfare within the Catholic, among Catholics about who speaks for the church, right? So you actually have very interesting theologians that I've been on panels with, for example, who say that there is no objection to the payment, for example, as a matter of Catholic doctrine, the payment for contraception. Interestingly enough, though, they would agree that that facilitation, I think the word that they use with respect to anything that's an abortion-causing drug would be complicity with the material evil. So in their sort of hierarchy of things, they would say, wow, one is really big and we can't touch that at all. And the other one we're not sure about, right? But there is a question about who speaks for the church. And I think when you have a large publicly traded corporation, there would be a legitimate question about who speaks for that corporation. And you could imagine that the shareholders might have one view, or might not even care. I mean, like, I want to make some money for my Apple stock, please, as opposed to this corporation having some viewpoint that they want to, put out in the world, in the marketplace, right? So I think it's more difficult. But have we seen any publicly traded corporations bringing lawsuits?
I don't know if you've seen any publicly traded corporations bringing lawsuits for this.
Uh-huh.
You see lots of them bringing, or lots of arguments related to objections about regulation of their marketing or of their speech related to their campaign contributions and so forth. So this is a sort of talking about social movements. The First Amendment seems to be certainly the all-purpose anti-regulatory amendment to the Constitution right now. I didn't ask you to ask that question, but I mean, it illustrates part of the problem, right? Is that we have state law that sets up the parameters of what a corporation is, and then publicly traded corporations have an overlay of federal law. You know probably what some of the difficulties are for shareholders to make their views felt on even even assuming that you have a majority of shareholders who have an objection to something, blood diamonds, what have you, being able to pull it out is really very difficult, and shareholder suits are very difficult to maintain. And typically, the spending of corporate funds for something like giving money to the ballet or giving money to a advocacy group are part of a business judgment rule and insulated from shareholder objections. So, these could override, a big company could override and ride roughshod, if you will, over individual objections that might be very compelling, but they are, the question is, does the corporation get to make that decision either for its shareholders or its employees?
Yeah, no, I think that's probably the hardest question. Yes, sir.
This isn't exactly for contraception, but it's sort of insurance-based, so it seems like same-sex marriage is probably common. Do these organizations have the same sort of grounds to oppose a spouse being insured if marriage comes through, same-sex marriage comes through?
Yeah, it's interesting that you asked that question, because the paper that I've drawn the talk out of talks about both fights. And it argues that the religious exemption, I work with a group of scholars that have actually argued for religious exemptions to the same-sex marriage laws. And it's an instructive debate, because that's the first place that I encountered the nuclear option. So when Catholic Charities, for example, asked the District of Columbia DC Council when it was passing its same-sex marriage law, please exempt us from the benefit mandate, the district said, no, we won't do that. And so what did Catholic Charities do? It stopped providing life insurance coverage for all spouses who were not already now covered, i.e., the folks who were already in traditional marriages. And the people who lost out were all the new employees. Now, it was a, quote, non-discriminatory response. They just stopped providing it for everybody, right? But they did stop providing it. They took the nuclear option when they were given no other way out. And I think the benefits question is the hardest one, because we are assuming that the rules that we pass can make these religious objectors come to heel, that we can force them to do what we want if the penalties are big enough. And we're finding out that that ain't always so. So I think it's really a story about the limits of the law when people are put to those kinds of choices. I will make one other point about the same-sex marriage debate that I think is also instructive. Early on, people thought that there wouldn't be so many religious objections, that this was just sort of a made-up problem. We're not seeing that. In fact, we are seeing people close down their wedding reception businesses. If they, for example, just happened recently in Maryland where there weren't exemptions forthcoming, right? So people are actually voting with their feet at great expense to themselves. But the other thing that we've seen is those religious exemptions themselves have made it more palatable for the same-sex marriage laws to be passed by people who may have been holdout votes, let's say, for example, in New York and Maryland. And I have a new article that actually, where my co-author, who's a PhD student now, but he worked with me on some of this work, has gone back to interview these exact same legislators. And you can identify specific votes that went over the top simply because you had the religious liberty exemptions. And what I have said publicly is that the religious liberty exemptions turned down the temperature on a deeply divisive debate. And I think here we could have turned down the temperature on this fight, this women's issue versus the church. It didn't have to be set up as that false contest. Sometimes, in fact, we can have both. And I think in a plural democratic society, we should always strive to have both things. That's just my personal view. It's a great question. Thank you.
The question of to what extent can religious objections be made to various types of benefits in this particular context is a troubling one, because historically, at least historically dating back to 1991, if you switch areas to end-of-life care and the decision to refuse hydration and nutrition, federal law, the Federal Patient Self-Determination Act of 1991, most state statutes allow Catholic hospitals and other religious entities who object to the removal of hydration and nutrition to do that, but they do it through a mechanism of transparency. There's basically this medical Miranda rights warning that has to be given upon enrollment in a Catholic HMO or a hospice program or admission to a hospital or a skilled nursing facility. What's interesting to me is that, in theory, religious objectors could go beyond that. That all involves direct provision of services by this institution with an institutional conscience. But if religious objectors were to take this posture and extend it to benefits coverage, could Hobby Lobby not object? Could they object to the provision of healthcare benefits that would allow going to a non-Catholic hospice to have hydration and nutrition discontinued from a patient? I think there's some very valid points to be considered looking at externalities of potential rulings in this area if the religious objectors were to prevail.
No, I think that's a great point, and it actually tees up something I want to be clear about. When you are talking about objections like in the Church Amendment, for example, which since 1973 has said no one will be made to do an abortion against their religious convictions, religious beliefs or moral convictions, okay? That there you have a direct collision between this person, the provider who thinks they're going to go to hell for performing an abortion, and the person who probably absolutely needs it. And I'll invite you to look at two recent cases, and some of it's little bit of it is in the article that I drew this from, but more of it is in a new chapter called The Erupting Clash. But it's a case about Kathy Sensen DiCarlo, who sued Mount Sinai Hospital, saying that she was forced to perform a 22-week late-term abortion over her stated moral objections and religious beliefs, which Mount Sinai had staffed around for 6 years, until one day, all of a sudden, somebody said, you're going to do it. In violation, not actually of the Church Amendment, because it turns out it doesn't have a private right of action, but likely in violation of New York law, which provides a mirror look-alike absolute exemption, assuming that it provides a private right of action. And the second suit is a suit brought by a dozen nurses against New Jersey's School of Medicine and Dentistry in a case called Danqua. And what they said is, you're forcing us to train for abortions and to provide abortion assistance against our stated religious and moral convictions, and against a whole set of conscience guarantees that actually came after the Church Amendment around the question of whether you have to be forced to train for abortions or provide that service, of something called the Coates Snow Amendment, and New Jersey law. And they actually reached and memorialized a settlement on the record that winds up where I basically have wound up in my scholarship, which is a qualified right to object. And the way the qualified right to object is, religious liberty wins until a woman is likely to die. And in that case, in a straight-up contest between religious liberty and access wins. Now, notwithstanding that, Mount Sinai staffed around Kathy Sensen DiCarlo for 6 years. The New Jersey School of Medicine and Dentistry has not come to a screeching halt because they reached this agreement on the record. And you can almost always staff around these religious objections. So there's not a reason to say, oh, well, when we have access on the one side and religion on the other side, access always has to win. No, the answer is we can have both, almost always. And we should have nuanced rules that get us to that result. And I'd be happy to share that piece called The Limits of Conscience. I'll also tell you that in the limits, I note the fact that many states, like Illinois, have had to figure out whether pharmacists, for example, are going to be exempted from the duty to fill prescriptions for Plan B or Ella or something else. And when put to that contest or that question of whether they're going to provide exemptions, what they frequently do is they say, oh, well, the facility, Walgreens, doesn't have to stock, but if they do stock, then the individual pharmacist has to fill it. Now, I think that gets it exactly wrong, because the individual objector is made to eat it every single time in that situation. While we allow facilities, here's a place where I don't have a whole lot of sympathy for Walgreens personally. We need to have access to this in the marketplace. And if you care about access, that gets it exactly backwards, because the facility not stocking something wipes out huge amounts of access. The little individual pharmacist who's standing there at 9 o'clock at night isn't wiping out very much access. One person by themselves. And you can force up to Walgreens the duty to staff around that individual objector. You, in effect, make it a little more expensive for Walgreens to operate, but you have both access and religious liberty. And that should be the nirvana point. That should be what we're always striving for. And I think nuanced rules do that.
If not, if Walgreens has a religious objection, so, this is the thing. I mean, it's like, and I think there is a stage at which you could say, to some extent, trying to reside moral, agency and personhood in a legal fiction is to some extent demeaning to the whole idea of moral rights and personhood and so forth. But so you see, like, they're on the sideline.
Sorry, I'm catching up. No, as you guys can tell, we've had two really distinguished speakers we're lucky to have. So let's give them another round of applause.